Hi, everybody. I'm Karen Sabatino. Sean invited me to come talk about legal support for game development. I am the legal support for Sean's company and also a couple other companies who I didn't get permission to disclose their names, but people you know, and if they come into this call, they're welcome to disclose themselves. So the idea here is that, when you have a video game company or you're planning to have a video game company, it's more than just the technology. You have to have the legal support in place if you want to be able to make money with it. So a little bit about me. First off, and just a full disclosure, I am Sean's mother, so I don't want that to be a surprise to anybody who doesn't know that already. I'm also an attorney here in Georgia. I'm in Midtown, and I have my own solo practice. I'm also of counsel to a law firm doing a totally different type of law. I'm a member of Sean's company, and I have helped a lot of video game development companies and just game development companies as well. I went to Georgia Tech and Georgia State. So first off, kind of my little quote here. Why do I have to think about this type of thing? And it's really before you start to make money or money flow, either pay money or money coming in, you need to take a stop and look at your legal structure. If you're just making games for fun, this doesn't matter as much. But if you're looking at it, doing it as a business, it does matter. So the things to think about here, first off, having a company, right? You want to make sure that you actually have a company when you want to go forward. So form a company. It can be an LLC, it can be an S Corp, lots of different ideas there. But you want to actually make sure you have your company set up. You want to make sure that your intellectual property belongs to you, right? Just because somebody did work for your game doesn't mean that the IP belongs to you. In fact, it doesn't unless you have a contract that says it does. And that's a huge loophole here that people don't always know. So you want to have contracts in place with everybody who provided for you: developers, artists, musicians, voice actors, script writers, everybody. And then on the flip side of that, if you're going to be selling, you want to have contracts in place with anyone who's doing your marketing, publishing, distributing. And that's actually the harder contract. And then end user policies, particularly if there's children involved, you definitely want to have your end user policies. Tax filings, I know that's not so exciting, but when money comes in, you got to do your taxes right if you don't want to be in trouble. And then just kind of like, when do you need specific help? So those are the different topics I want to cover. And with that, let's move to the next slide. Okay, so let's first focus on the company formation. The first question would be, why do you need a company? And it's to separate yourself from your business, right? Because otherwise your business is you, which means you can't have multiple people in a business together unless you have a company, because if it's just you, it's not multiple people. Risk mitigation, if there's any risk, you don't want it to come back on you. You want it to come back on your company. So it makes collaboration a lot easier. If you want to have an investor, you have to have a company for them to invest in. What type of company? Most people, an LLC is easier. They're way easier to maintain. The advantage of an S Corp, which is actually what we did for Sean's company, Corrupted Media, we did an S Corp because we wanted investors. So we actually were able to sell shares. You can't do that with an LLC. Sean had a little more help built in to being able to run the company. So we went with the S Corp. But for most people who don't necessarily want to have a board and want to have shares of stock and all that, an LLC is easier, and they're much easier to maintain. Ongoing implications, you have to register your company with the Secretary of State every year. So it's not just setting it up, it's the annual registration. You've got to keep your accounting going. So you've got to keep your financials separate from your personal financials. You got to file tax returns every year. And we're going to talk about that later. With an LLC, sometimes you can put it on your own tax return. And then you have to understand the people who are contributing. Are they employees? Are they contractors? Those are treated differently. And we're going to talk about those things a little bit later too. Okay, so intellectual property. This is where I probably get the most questions. And the key here is that the intellectual property in your game is not yours unless either you created it yourself or you have some kind of a contract somewhere that the creator assigns it to you. And assign means basically grant it to you or give it to you. So just because you pay somebody to do something does not mean you own the output, which I know is totally counterintuitive because you would think if you pay somebody for something, it's yours. But for intellectual property, that does not happen. So that's why it's so important to have some kind of a contract. And these can actually be fairly easy. Generally, when we do them, we want to put other things in them to protect you since you're doing the contract anyway. But a lot of times we can set up templates, and then you can use a template over and over again for different contributors. No matter what they're contributing, you can use a very similar form. So once you have your template in place, it's not that hard. But the important thing here is that you have to make sure that everybody who contributed signs this before you start making money, because you don't want to have, you make a whole lot of money and then someone says, well, wait a minute, I own that. And then you have a problem. So that's not what you want. Exclusive versus non-exclusive. You don't have to have exclusive rights to the IP. You can have shared rights, and that's all something you can work out in the contracts. Copyright, that protects your code, your images, your music, any of those types of things. That's the main part of the intellectual property that we're working on at this, for game development. Trademarks are the name of your game. So generally for independent developers, we go with just common law protection, put the TM after it. You can register it with the state or with the federal government. The federal government's very expensive, so you generally don't do that unless you have a lot of money coming in, because it's expensive to maintain. But you can register with the state just for defensive purposes. And all that really does is kind of put a stamp down saying, I used this name in business for my game at this point. So if anybody comes along afterwards and says, no, 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 I used it first, you have a record with the government saying you were already using it, which protects you. It doesn't let you go after infringers, but it protects you from other people who think you might be infringing. So that's something to think about too. But the assignment thing at the top is by far the most important. And then trade secrets are the things that are yours that you don't want to share. So that's where non-disclosure agreements come in. So if you're going to be looking to collaborate with somebody and you want to show them your code, but you don't want them to steal your code and run off with it, that's where you put a non-disclosure agreement in place. And it basically says, I'm going to share information with you, but you are only allowed to use it for the purposes of working with me or whatever purpose you lay out in the non-disclosure agreement. And again, that's something that we can have templates. So kind of some of the different things to think about from an intellectual property point of view. So moving on. Okay, so we're talking about contracts. So the first batch of contracts, and I talked about templates for these, I laid out a bunch of different types of contracts. Most of these can be done with templates to make them easier. So independent contractor agreements, that's for somebody who's contributing. So you're paying them either a set amount or an hourly amount or whatever it might be, but you're paying them for work. You want to make sure that you own the work. You can do it where you pay them hourly, or you can do it in batches where you can have like a statement of work for, I want to pay someone to create 6 images or whatever it might be that you need. Contributor agreements, those are for unpaid contributors. We see that a lot where somebody contributes to a game just because they want to for fun, but you still have to have the intellectual property assignment, but they're not getting paid. So that's a little different, because if you're not paying them, you can't really ask for some of the more legal protections. You just have to ask for the ownership of the IP. Royalty agreements, that's where if someone's contributing to you, you agree to pay them part of your profits when and if you make profits. So that's a little different than like an independent contractor agreement where you're paying them for the work. For a royalty agreement, they don't make money unless you make money, but they still have to sign over the IP. And that's really a good way to do it because it's fair. If you don't make money, why would you pay the person who helped you? So those are another approach. IP purchase agreements, that's when you buy something. So we see this a lot of times with music, where maybe a song is already existing and you just want to buy rights to use it in your game. That's where you might do a purchase agreement. And again, we can do templates for these. Templates save you money because I can design a template one time, to kind of look at your whole game, your whole business, and then you can use it over and over. So just different approaches to some of these things. So the next one is talking about contracts again, but this time on the other side. This is where you're trying to sell your game. So it's with publishers, distributors, anybody who's doing marketing for you. These are a lot more complicated. Usually you're not the party with the bigger negotiating power here, so you can't really use a template. You've got to go with what the other party wants to use, and they may have a very complicated contract that doesn't make any sense to you. So this is where you actually need to bring a lawyer in to help you, not just draw up a template, but actually look at it and change it and explain anything that could be problematic, and then suggest other language to make it less problematic. These tend to be very complicated, and they tend to be have like a lot of different financial things about you get this money in this case and this money in this case, and they tend to work over longer periods of time. So this is where if you're going to put your money for legal support anywhere other than templates, I'd put it here. Because if you do your contract the wrong way, you may never make anything. The publisher may make all the money. And there's some things to think about too. Definitely, length of the deal, anticipated changes in the deal, what your obligations are. You want to make sure that your obligations are clear, and then the marketer's obligations are clear. Okay, and then the next one is about contracts, which it's not really contracts, but it's essentially contracts with end users. So this is where like EULAs, policies for privacy, those types of things come in. And these, again, you can very often go with, template type things. They have to be somewhat customized. Like, for example, with a privacy policy, you have to identify the types of data you're using. But for the most part, these can be fairly generic and don't take too much time to write up. But usually you need them if you're going to be publishing on some kind of a service that requires these sorts of things. Okay, so tax filings. Tax filings are probably the least fun part of all this. So even if your business isn't making money, if you have a business like an LLC or a corporation, you have to file your taxes, even if you're not making money. And there's some different things to think about here that take some planning. For example, if you get a grant, that counts as making money, right? So you've got to make sure that you don't end up having to pay a lot of taxes on that, end up losing the entire grant to taxes. So there's a lot of things to be thinking about on taxes. A lot of times you can talk tax strategy without having to spend a whole lot of time on getting someone to help you with your taxes, if you can just explain what it is you're trying to do. So the easiest way to do this is if you have an LLC with a single owner or a married couple who's the owner, because in that case, you can turn in your business taxes on your personal tax return, which is by far the easiest way to do it. That's called Schedule C, and it's done right on your individual tax return. Like if you get TurboTax, you just put it right into TurboTax. You've got to keep your accounting separate so that you have, your personal information separate from your business information, but you don't have to file a separate tax return. And if you have something like TurboTax, it walks you right through it. So it's not that hard. If you have what's called a multi-member LLC, which means more than one owner of the LLC and they can't be married. So a married couple counts as a single owner because they filed their taxes together. But say, two people who are just friends or business partners work together on an LLC, they can't file it on their personal taxes like that. They have to file a separate tax return for the business. And then that creates what's called a Schedule K1 that they use to put the information into their personal taxes. So you can see it just went up a level in complexity. So that's why a lot of times when you set up an LLC, it's better to have one person be the owner and other people just have a contractual relationship to make the taxes easier. But then obviously as your business becomes bigger, that's not going to always work forever. But for simplicity, it's a good way to start. And then IRS forms. So this is an important one if you're paying people to do work for you. Anytime you pay an independent contractor more than $600 a year, you have to give them a Form 1099, which is an IRS form, showing that money. If you don't, you're actually in violation of the IRS. So it's a place you don't want to be. Also that 600 number is actually going up. So it's $600 a year for the 2025 tax year. It's going to be higher for the 2026 tax year. I don't remember exactly what it is, but it's going up quite a bit. But for the rest of this year, it's 600. To do that, you need that person's social security number. People are much more willing to give you their social security number before you pay them. So my recommendation is get it before you pay them. And that's what that Form W-9 is. It says on the screen IRS Form W-9. That's the form you use to get the social security number. And it's an IRS form. They fill everything out and give it to you. And then you have all the information you need to be able to issue their 1099. And again, these are all things I can help you with if this is confusing. This presentation isn't really like a step-by-step how to do it. It's more here's a scope of things that you got to think about. And then if you need help with them, you know what to ask for. I mentioned earlier, you want a separate bank account for your business, and that's to keep it separate. So part of the point of having a company is to protect yourself risk-wise, so that any risks your company has, financial risks, someone wanting to sue you, someone who thinks you owe them money, whatever it might be, is separate from you as an individual. If you mingle your money, if you put your business money and your personal money in the same bank account, that person who's coming after you can come after your personal money and your personal assets. It's called piercing the corporate veil, which is a term you may have heard. But that's why it's so important that for a business to have a separate bank account for the business, and then make sure you keep things separate so that you can very clearly say, this is business money, this is personal money. These are business assets, these are personal assets. So that's why the accounting matters. Employees. So we talked earlier about independent contractors. It's also an option to have employees, which you pay on a W-2. And that would be like, if you worked at a Walmart or something where you get a paycheck. I do not recommend having employees for your businesses at this point unless you get really big or there's some specific reason why you want employees. Independent contractors are much, much easier to handle if you're a small business. You don't have to do tax withholding for them. You don't have to handle all the payroll issues. You just pay them exactly what, if it's $30 an hour, you give them $30 an hour and send them a 1099. If it's W-2, you have to do tax withholdings for them, and then you have to calculate those tax withholdings and give those to the government. You can use a payroll processor company to do that for you, which helps, but then you got to pay the payroll processor company. Also, employees have a lot of legal protections, and you've got to be aware of those as far as work hours, work environment, what you provide them to work with, all that type of stuff. So for small businesses, particularly tech businesses, I don't recommend employees. I recommend independent contractors. And again, there's always exceptions, but in general. And then minimizing tax. That's a big one. And I mentioned it earlier about grants. Grants aren't the only thing. You want to have your income kind of be steady, because if you have a whole lot of money come in like late in the year, because maybe your game went wild and you sold lots of copies, you may end up with a huge tax bill that year that you can't do a lot about. So anytime you have a lot of money coming in, it's good to consult with somebody on taxes to make sure that you've thought through not having to spend all that money in taxes. Because unfortunately that can happen. I've heard horror stories about that. Okay, so whoops, I went too far, sorry about that. Individual legal advice. I mentioned a couple of times in here about the things that you don't necessarily need a lot of help. That's pretty easy to figure it out on your own if you know the basics. The things where you can get a template to help you, and the things where you really kind of need legal advice. So I want to go back to that last category, the things where you really need legal advice. Collaboration planning, protect your IP. You need that up front, but then again, once you have the templates, you're fine. Contract negotiation and development with the publishers, distributors, and marketers, that's probably one of the big places you need it, because those people are looking to make money and they're more sophisticated than you are from a legal point of view. So they're going to give you complicated contracts that confuse you, and you probably need help to make sure that everything is, going to be in your best interest, and they're not just going to make all the money and you don't get any. So that's an area I definitely recommend advice. Grants and investors, anytime you're getting a grant or taking on investors, you want to make sure that's structured properly so that you don't end up with problems later on, or you don't end up with a huge tax bill. Anytime things don't go as expected. So if you run into a problem where, maybe you have a contractor who is very upset and is, saying negative things about you, or thinks that they should have gotten something they shouldn't, or whatever it might be, that's where you might need some legal advice. Addressing any ambiguity and misunderstanding. So if you've done your contracts well, you shouldn't have a lot of ambiguity and misunderstanding. However, when your contracts aren't done well, or just something totally unexpected comes up, that's where you have problems. If one party thinks something and the other party thinks something else, you get the situation of ambiguity. And that's where you run into a lot of issues. So as soon as you see those coming, that might be a place where you want to ask for some help. And then just resolving conflict to avoid unfortunate consequences. Even if the other person's being dumb, you still might want to work on resolving that conflict to make sure that you don't run into a problem where you have no idea what you're doing. Okay, so I think with that, we are ready to go into questions. I have my data here. I'm available. That's part of why I agreed to do the presentation, is I actually am taking on clients right now. It's $100 an hour, so it's very low cost because I work out of my house. I don't have any overhead costs here. And I have my info on here, and I'm sure you can get it from Discord as well. And I think with that, we can go to questions. I don't see any questions in the chat, but it's possible I'm overlooking them if there are any. Are there any questions? I see the question. Can I use ChatGPT to make contracts for me? Yes, you can. It's a very good place to start. However, it's not where you want to end. You can use Chat GPT to get the basis of a contract, and then you can start maybe plugging stuff into it. That can save you some time, so that when you do have a lawyer look at it, they already understand what you're trying to accomplish, and then they can go through it much more quickly and just make whatever changes are needed. I would not rely 100% on Chat GPT because it makes mistakes, and it's not. I'm not really trying to diss Chat GPT. It doesn't always really know what you want. And if you're not a legal professional, you may not be asking the right question. You may not be wording your question properly. So very often ChatGPT will come back with something that answers the question you asked, but the question you asked isn't really complete for what you should have asked. So I'm not at all opposed to using it. I actually use it all the time to get templates, but I would never use something straight out of it. I would always go through and modify it to make sure that it has everything it needs to have. But it's a good place to start. I think I see another question coming in. Have you experienced any common issues with sync listening music in video games? Um, Not really. I can't say I have. And I'm not totally sure I understand what sync listening music is, and I apologize for my lack of. I am not a gamer. I have lived with gamers for the last 30 years, but I am not a gamer, so it's quite possible I don't know what sync listening music means. I'm familiar with music in video games, and I see people are responding to me here. Music made to be licensed to video games. Okay, okay. I have not seen problems with it. It is important to get the license right, though, because the language in an IP grant is very, very specific, and words have legal meanings that may not be obvious. Like I was editing a contract for somebody today, and it wasn't for the video game industry. It was actually for a software development company. But the person kept using words thinking that they were doing an IP grant, but the words they were using aren't actually an IP grant. They were saying, I'm not going to limit you from doing this or something like that. But the wording wasn't an IP grant. So I think the key here is if you do your license properly, you're fine. But doing your license properly isn't always easy if you don't really know the right words, because there's all kinds of aspects of intellectual property. There's license to use. There is a license to make derivative works, which would mean like to include it in your product. So if you just get a license to use, but not a license to make derivative works, you can't put it in your product. You can just use it as is. You also need to have the ability to sublicense, right? Because when you sell user licenses for your product, that's a sublicense of that original license. So that's why the language matters. A license is one thing, a grant is something else. A grant is full transfer, a license is partial transfer. Is it exclusive? Is it non-exclusive? Do you have the ability to just use pieces, or do you have to use it in its full thing? There's the concept of moral rights, where if you're not using it in the way that the songwriter wanted you to use it, they can have an issue with you. So there's all kinds of different things that can go wrong, but they're all things that can be addressed if your license is written properly. So I guess that's why I really haven't seen problems there, because I haven't seen one yet with a poorly written license. I'm sure they exist. I think the biggest issue is when you don't have a license and someone just uses it. So hopefully that answers the question. Let's see. Okay, I think I got that question. Are there any more questions? I just see some thank yous. You're very welcome. I see more questions coming in, so bear with me. Oh, I thought I saw more questions coming in. I think I was mistaken. Okay, well, if y'all don't have more questions, I think that's it. I would kind of be surprised if there aren't more questions, because we went over so much content and I went through it pretty quickly. Sorry, I see people in the chat, so I'm waiting to see if they actually are asking questions or not. Okay, I see a question. What is the best way to get legal support when I don't have money to spend? Well, and that question actually came from Sean. So Sean is a very good example of somebody who is fortunate that his mother does legal work for his company for free. But that's not really the right answer. So when you don't have money to spend, I would say the best way to get support is focus on what are the key things you need and then make them as easy as possible to do for the lawyer. So like Sean's question earlier about ChatGPT, if I can get someone who gives me a basic contract that's what they think they want, I can review that very quickly and give feedback. Whereas if I get someone who just says, I need this without the details, it takes a whole lot longer to get there. So I would think streamlining what you want to make sure what you want, you've given as much information as possible in a very organized format. And when I went through the information earlier, I tried to focus on where it's most important and where it's less important. So like if you can, spend an hour of someone's time to get a good template, you can use that template over and over. So you don't have a lot of cost. Whereas, if you need something customized, it's more cost. Another thing is, of course, the internet is a wonderful tool beyond ChatGPT. You can Google things you want to get an education for yourself. I mean, y'all are bright people. I just know that, you work in a different area. But learning through the internet, I still value for this. I would just be very careful about if there's things that either you don't understand or that seem a little more complicated. Just, you don't want to make a mistake now that ends up making a long-term mistake later, particularly with intellectual property. Because if you make the mistake of not getting the IP assigned to you and then you make a lot of money, the person who didn't assign that IP to you has a very, very strong negotiating position. So, just look for those types of pitfalls. But as far as how to do it cheap, I would just say educate yourself the best you can and rely on templates and prioritization. Let's see. How did you get into the industry? Well, that's an interesting one. I am actually an electrical engineer and I'm an attorney and I have a business degree. So I got into technology, a long, long time ago when computers were actually brand new, which, I'm 55. So computers were very new when I was at Georgia Tech. The reason I don't have a computer engineering degree is Georgia Tech didn't actually have one yet. It was still part of electrical engineering. So I got into technology a long time ago. And then I was working for the power company and got my law degree working for the power company to focus on intellectual property for them. I left there about 5.5 years ago and have just been doing a wide variety of things. The way I got into video game law is actually when Sean wanted me to help his company, because when COVID hit, I was working doing a whole bunch of different things. And Sean was, graduating and there was not a lot of jobs back then. So he decided to get together with his business partner to set up their company and they needed help. So that's actually how I got into video game law. And then based on that, I've actually kind of created a little bit of a niche for it. I work through a company called Contract Counsel online, where I can pick up clients needing legal work all over the place. And I charge them a higher rate. So I don't recommend you go through them. If you want my help, come to me directly because there's a 30% markup if you go through them. But I help video game companies through that too, just based on the experience here. And then of course, one video game developer and they introduce you to their friends. So I end up with a lot of people that way. So it's kind of a really interesting niche to be in, but it is not the only thing I do. I also practice community association law and I'm a part-time professor and I do a lot of tax law. Let's see. Oh, Sean's asking for a friend. Got it. Okay, and I don't see any other questions that came in, but I do see people typing, so I'm going to give it a minute. Okay, when hiring contractors, could an IP grant be inferred if within a reasonable inference? Absolutely not. There's a lot of established case law there. If it's not explicitly written out in a signed contract, there is no inferred IP ownership transfer. That's a huge issue because it's very counterintuitive. You would think if you pay for something that it's yours. But in the case of intellectual property, it's not true. And that's kind of why I wanted to drill that in as a very important point, because it's an easy place to make a mistake. And it says, for example, if someone hired person X to create content for project X and you have that kind of ownership implied outside the scope of a contract, could that be a valid claim of ownership? Yeah, same thing. Absolutely not. Huge issue. And if you take anything home from this presentation, it should be that. Because that's really why I'm kind of pushing the idea of having an independent contractor template that you use for everybody, or independent contributor template for everybody that works for you. or that develops for you, because it is not inferred. And that's been a pitfall for a lot of people, not just in the game development industry, but technology in general. It's a little more understood now, at least certainly by bigger companies. But earlier on in technology, there was a lot of people who didn't make money that should have made money because they never signed the rights for their IP over, and the person who owned the original IP got it. So yeah, big problem. Okay, another question. Are there restrictions to what can be protected within a game? For example, could I patent a mechanic or feature of a game? Good question. So patent law went through a shift a whole bunch of years back. It used to be you could patent software. And that created a very interesting environment because, software is really nebulous. So the idea of patenting software was creating all kinds of problems. So they changed the law maybe 10 years ago. I don't remember exactly, but they changed the law a while back. And now most software is not patentable. It occasionally is if it's integrated into hardware or some kind of a mechanical process, but for the most part, software is not patentable. So most of the work y'all do is not patentable. And I know you say my software runs on a computer, but that's not sufficient. It has to actually be something that's very unique, like a driver for some unique form of equipment, not just, I run on a computer, or I run on a tablet, or I run on a phone, or even a VR headset. Those are kind of generic. So for the most part, software is not patentable. That's why we rely so much on copyrights for software. And you can register your copyrights. However, again, software is nebulous. So, if you're Microsoft and you're releasing the latest version of Microsoft Word, it makes sense to do a federal registration. If you are not, and you know that you're going to be making changes all the time, it's much better just to do a copyright notation on it. And you just, the symbol you see of a little copyright symbol, copyright, date, your name, all rights reserved. And that gives you a level of protection. Mainly just saying that this is mine. But patenting is really not a big piece of software development anymore. It used to. Good question. See, okay, I don't see any more questions. So y'all tell me if we're done or if there's more questions coming in. I don't see anybody typing.
Yep, I don't see any questions coming in either, so I think we can call it a wrap. We have someone asking to speak. Could you just drop your question in the chat, please? If you have a question.
Oh, no worries. I'm fine to address a question twice. I mean, it's like the question we had earlier about, inferred IP grants. Very good thing to bring up because that's something worth hearing more than once. So it's okay to ask questions twice. Okay. So speaking of patents, for gameplay mechanics like Shadow of Mordor's Nemesis system, how complicated is it to navigate implementing such mechanics without being beholden to paying the rights holder for these systems? Is it really cut and dry, or more like a gray area? So I want to make sure I understand the question. If we're talking about reverse engineering, then you can't copy someone's code directly, but you can copy concepts that aren't patented.
So I can chime in to help here a little bit.
Thank you.
I can speak at least to the Shadow of Mordor's Nemesis system, because I don't expect you know what that means. But there was a game by Warner Brothers, so it was huge company, came out a while back, and they had a feature that was very unique to the way that the enemies would work in the game that no other game had done before. That was really novel and pretty cool. And they made it very clear that the way that they patented this feature, that no one else is allowed to have this Nemesis system to make the enemies work the way that they do in this game, and only the company, Warner Brothers, basically is allowed to use this feature. But then the company under Warner Brothers that actually made the game Shadow of Mordor and owned the license to this Nemesis system just got shut down earlier this year. And so there's a lot of talk about how this Nemesis system, or this way that enemies work, is could theoretically die with them, even though it's something that's very easily replicable. It doesn't even require reverse engineering. It literally is just whether or not a game would get sued if they tried to do something similar to it.
Okay. Do you know that they patented it? Did they just say they patented it, or did they actually like produce a patent? Or do we not know?
I mean, I haven't seen the patent myself, but I don't think Warner Brothers would lie about that.
Well, I guess where I'm going with my thought process is that's really very much in the gray area of what's patentable. So I would wonder if when and if someone challenges that patent, if they win or not, because that's very much in the gray area of what's patentable. And I'm sure they have some case about it's doing something unique in relation to the hardware that, they can use as a justification. But if challenged, that patent may not hold up. However, we're talking millions and millions of dollars of lawsuit fees. So you don't want to be the one to challenge it, because then if they sue you, you have to defend, right? Which you don't want to be that one. You want some big player who has money to be that one. So my guess is over time, somebody will challenge it. Someone will go ahead and, reverse engineer it or copy it, depending on what they have access to. Probably reverse engineer it, put a product out that does the same thing. Somebody will sue them if there's a patent, and whoever gets that patent will sue them. And someone will own the patent. So if it's Warner Brothers, whoever they sell it to, or, however it goes, someone will own the patent. They can sue them. And then at the end of that court case, we will find out, is it a valid patent, and did the reverse engineered item infringe it or not? So my recommendation is wait for that to happen. You don't want to be the one challenging it. You want someone who has a lot of money to challenge it. But then once we find out, everyone is free to go forward with whatever the decision is. It's not knowing a lot about that specific tech. I would not be at all surprised if the patent wasn't considered to be enforceable. Does that answer the question? And I'm reading this now. It says, the Nemesis system patent held by Warner Brothers Discovery protects the unique gameplay mechanic found in Middle-earth, Shadow of Mordor, and Shadow of War. This patent, initially filed in 2016, granted in 2021, grants Warner Brothers exclusive rights to the system's core features, including procedurally generated NPCs, their interactions with the player, and social conquest battles. The patent is valid until 2036, potentially limiting other developments. Yeah, I have a feeling if challenged, that patent's not going to hold up. But the thing is, someone has to challenge it, and that's an expensive court case. And then I see another person typed in, from what I understand, and this could be inaccurate, Nintendo has a patent for catching monsters inside ball-like containers. So yeah, more broadly, if companies have tried to patent gameplay mechanics. But yeah, the question is, back about 10 years ago, when the law changed, it was allowed. So you could file patents for exactly those types of things. In fact, I did that. Part of what I was doing for the power company was filing patents on, not from gaming, but those sorts of things in software. The law changed, and someone has to go through, though, and actually challenge those patents to have them named invalid. So the problem is, you don't want to be the one to do that because you don't want to get sued. So you have all these patents out there that probably aren't enforceable, but everyone's afraid to infringe them and to find out they aren't enforceable until somebody with deep pockets does that. So that's why you have this kind of strange situation where something filed, 10 years ago is still considered to be a valid patent when maybe it is and maybe it isn't. My recommendation is just stay away from that because you don't want to be the one they're coming after. But then if you find out that someone else challenged it and it got ruled not enforceable, then it's free for all. Okay, let me go back and look at the chat. Okay, and I think Sean posted, Nintendo sued Pal World for infringing the patent and lost, right? Yeah,
this is actually for a different patent, but
sorry.
Yeah, this is actually for a different patent. But
okay.
There was apparently Nintendo had also patented that they're the only ones allowed to make games about catching monsters inside of balls, as in Pokemon. Mm-hmm. And there was another game that came out, was it last year or the beginning of this year, that had something very, very similar. And so Nintendo is actually actively suing them for infringing on the patent. But to my knowledge, I don't think the case has been going well. I think Power World's been able to make a case that it's not something that they're allowed to prevent them from doing.
Yeah, and that's Because when that happened in patent law, it was very, very important. It was called the Alice case, and it was a huge case in patent law. And it actually ended my time in patent law because I had been spending a lot of my role with the power company at that point was patenting software that was unique. And then we were looking at, how can we make money off of that? And when that case hit, all of a sudden, all that software wasn't going to be, you really couldn't sell those patents anymore because nobody knew if they were going to be enforceable. So what y'all are seeing is patents that were filed 10, give or take 10 years ago. And that's why you're seeing this. But yeah, it used to be, the history of a patent was really kind of based on machinery. So it was like, I built a new steam engine with a new type of valve that does something. And then when software came along, at first the software was very tied to the hardware. So it was, I built something that makes this particular piece of hardware work. And then later on, when the hardware became almost generic and software worked on everything, you started getting people patenting very, very subtle things in software. And if you think it through, it's ridiculous. I mean, why would you be able to patent a type of software that puts a Pokemon in a ball? What's the value for that? That's a storyline. That's not a device that you're going to be using in industry. And so the whole basic purpose of patent law had kind of gotten changed from its original purpose, which was I invent something in industry, and then I have to be able to recoup the value I invested in doing that. And if my neighbor goes and copies my invention, I'm not going to be motivated to make more inventions. That was the whole purpose of patent law. We still very much see that in medicine, where you come up with a new form of medicine and you get a period of time where you're the only one that can sell it. So you sell it for a fortune. And then, so many years later, it becomes generic. So that model still kind of works in medicine, but for software, it just really doesn't because you're limiting more of a concept rather than an actual invention. So that's why they changed the law. And it was done through a case. It wasn't actually done through, well, there was actually new statutes too, but there was a case that really changed it. But I think what y'all are seeing is kind of the ripple effect of that. So I think given enough time, none of these patents are going to be enforceable anymore. But, and I think in the chat, I'm seeing the same thing. You don't want to be the one to do that because none of y'all have the money to defend. You want someone like a Sony or a Microsoft or somebody with a lot of money to be the one to defend that. So my recommendation, if it's a gray area, stay away from it. Okay, let's see. I see a lot of thank you for the word of warning. Yeah. And as a lawyer, my general advice is if something's really risky, consider not doing it. If you have to ask the question, maybe you know the answer already is kind of where I'm going there, particularly if you don't want to spend a lot of money on legal fees. Okay. I think that's covered everything unless there's more questions.
Nope. I think that's going to be wrapping us up. If anyone does have questions, feel free to chime in now. But otherwise, we can thank Karen for her time to come out and share all these great insights with us today. And her video will also be posted on our YouTube channel if you want to review any of this content later. And then if you want to stick around for the online meetup, Brick will be hosting that very shortly down in the general VC. We'll be playing not Roblox, sorry. We'll be playing Jackbox today. And I'm very excited to hear how that goes. But otherwise, thanks everyone for showing up, and I hope you enjoy the rest of the meetup.